When Dean Reuter asked if I would give the introduction for the speaker of the day today, I leapt at the opportunity, both because today's speaker is such an easy topic for an introduction, but also because it seemed particularly fitting, given that Miguel and I first met just over 30 years ago, and the man responsible for that meeting is someone who I expect will figure prominently in today's presentation, the then newly confirmed Junior Associate Justice of the Supreme Court, Anthony M. Kennedy. Both Miguel and I were privileged to clerk for Justice Kennedy early in his tenure on the court, and we owe him a great debt of gratitude. But beyond that, I think it's fair to say that the nation as a whole owes Justice Kennedy an immense debt of gratitude for his remarkable record of faithful service to the Constitution and the rule of law over the course of 4 decades on the bench. Justice Kennedy, we salute you. And while I'm on this topic, I would be remiss if I didn't also say this. Well done, President Trump. Well done for selecting such a stellar nominee to fill Justice Kennedy's seat. No one is better qualified for that position than Brett Kavanaugh. May he serve with fidelity to the Constitution and to the cause of principled legal decision-making for decades to come. I suspect we will be hearing a bit more about these topics, and also, of course, about the recently concluded Supreme Court term, which was both unusually eventful and unusually salubrious. Today's speaker is supremely qualified to address those topics. He's no stranger to this podium, having delivered the annual Supreme Court Roundup to great acclaim on multiple prior occasions. His sterling resume is too packed with remarkable accomplishments to detail in full, so I will mention only a few of the highlights. After graduating from Columbia University and Harvard Law School, he clerked for Judge Amalia Kearse on the Second Circuit, and of course for Justice Kennedy. He worked at Wachtell-Lipton, which views itself as the elite special forces of the M&A bar. He served as an assistant United States attorney in the Southern District of New York, which views itself as the elite special forces of the Justice Department. He then served as a line attorney in the Solicitor General's office, which also views itself as the elite special forces of the Justice Department. And for the past 2 decades, he has been a highly esteemed and sought-after appellate litigator at Gibson Dunn Crutcher, which views itself as the elite special forces of the appellate bar. Miguel has argued 23 cases in the Supreme Court and dozens more in the lower appellate courts, and his legal acumen and unexcelled ability to skewer legal opponents with the mot juste are widely celebrated. As one would expect of a lawyer of Miguel's prominence, a lot of people have said a lot of things about him. In fact, I thought about making this an audience participation moment, but instead I'm just going to provide a small sampling. See if you can guess the speaker before I identify the source. So Miguel has been called a model of professionalism and competence. My mother? Seth Waxman, a former Solicitor General. You'll make your own judgment on that. He was described as outstanding, diplomatic, cooperative, and candid by Paul Bender, former Principal Deputy Solicitor General under Clinton. That was in your performance review, Miguel, not when you were nominated to the D.C. Circuit. Now, Mr. Bender's commentary that Miguel is outstanding is certainly accurate, and candid is, if anything, a gross understatement. But diplomatic? I guess we'll find out today. Another observer has described Miguel as a towering intellect with a prodigious capacity for hard work. That was Justice Elena Kagan. She's also said that, quote, "No one I know is a more faithful friend or a more fundamentally decent person." And I can certify that her descriptions of Miguel are precisely accurate. Now, in the interest of full disclosure, I have to acknowledge that when Miguel dipped his toe into the cesspool that is our judicial confirmation process a few years ago, not all of the comments were quite as complimentary. One source said that Miguel has a reputation for taking extreme positions and is driven by an unusually conservative agenda. And that was the New York Times editorial page. Of course, any conservative agenda, and for that matter, any conservative, is extreme and unusual from the perspective of the New York Times. It's the same phenomenon that led one of my Yale Law School professors many years ago to exclaim that he couldn't understand how Ronald Reagan had won re-election by a landslide, since he didn't even know anyone who knew anyone who had voted for him. Perhaps most famously, Miguel was called, quote, "a stealth missile with a nose cone coming out of the right wing's deepest silo." That was, of course, Senator Chuck Schumer. Now, Miguel has been characteristically candid about Senator Schumer in return. As you may recall, last year, Miguel was being suggested as a possible Solicitor General nominee, and he responded to press speculation about that by saying, and I quote, "I would never willingly place myself in any situation in which convention requires that I be civil to Chuck Schumer." Let's hope that Brett Kavanaugh has greater intestinal fortitude than that, because he's going to need it. I could go on, but when all is said and done, the quotation that best encapsulates the prodigious talents of our speaker is this. On the wall of Miguel's office hangs a photograph of perhaps the foremost legal colossus of the modern era. On it appears the following handwritten inscription: "To Miguel, who, if I were always right, would have clerked for me. With warm regards, Antonin Scalia." Please join me in welcoming Miguel Estrada.
I don't know quite how to live to that, since I'm supposed to be a member of the elite forces, and I am as tall as Michael J. Fox. But I guess we'll see what we can do. Thank you, Tom. I am always thankful to the Society for having me. I guess this sort of drudge job of reading all these cases year after year is so thankless that, once again, it goes to show that there's some jobs that only foreigners will do. I'm actually a naturalized U.S. citizen, just in case some of you are thinking I should be on the other side of a wall. But you know, it's been a great year, and we're looking forward to another great year. President Trump has put his stamp, his own unique stamp, on our country and on our politics and our daily lives. And he has managed, thankfully, to begin reshaping our federal courts, for which we're all thankful. It is all the more, remarkable that he has done that, because he has done this in the middle of the on-again, off-again meetings with Kim Jong-un. I wasn't quite sure whether he was being interviewed for the vacancy in the Supreme Court, or whether he was just sort of pursuing, the dream that this nutjob would actually give up his only means of survival. But again, the president did this, staffing our courts while doing that, tolerating, the mooch for a whole 10 days, which is more than most people manage, and putting up, with an investigation of this sort of special counsel, which has to be quite a chore for the president, and you can understand why it gets to him. Now, I knew Robert Mueller sort of slightly some years ago. I actually happen to think that he's a man of the greatest integrity. It is perhaps somewhat unfortunate that he felt it necessary to staff his investigation with everybody who was floating away from the Obama sort of administration on a boat, and or of the Clinton campaign, and sort of you can understand why the president thinks that maybe that was not sort of all that fair to him. It also might be sort of more fair if you didn't get a subpoena from Mueller just because you read Dostoevsky, but seems to me he's overly suspicious. But things are sort of becoming more even and more balanced in the Mueller team now that Rudy has joined them and is flacking for him on television frequently. Anyway, the president is putting his imprint on the federal courts. He has appointed 21 judges to the Courts of Appeals, and we needed the help. And there are 13 more pending. That is incredibly impressive. The president is to be commended for that. That may be one of his greatest legacies. And I think that is something that we ought to be thankful for. And something that we ought to commend him for. And so, here for President Trump on this very important issue. Now, I'm not sure you've heard, I think Tom mentioned that at the end of the term, this has gotten very little press, Justice Kennedy announced that he's sort of, retiring at the end of July. He had a great term. He voted with the liberal wing of the court in precisely 0 of the 19 5-4, decisions. He was doing so well, I was thinking of keeping him. Well, no, really. But on a serious note, I actually, those of you who have come over the years know that I have often, lampooned the justices' writing style, because sometimes it does sort of seem like Hegel written in German backwards. But I have to say that I have a lot of affection, respect, and admiration for the justice's long career in public service. And I think the country does, in fact, owe him a debt of gratitude, because although the society may not have agreed with everything that he did over the years, he had a distinguished career of public service when he could have done a lot of other things in private practice and provided much better for his family. And over 4 decades, he selflessly dedicated himself to the service of this country and used his best judgment in what he thought was the best way to do what was right. And although, as with other public servants, we may not agree with his judgment in every case, he deserves our thanks and admiration. And in a less serious note, unlike some other public servants, John Paul Stevens, are you listening? He knew to dance with the one who brung him, which actually shows that he has some class as well. And so for Justice Kennedy, for those of you who are still sort of smarting over some of the rulings that you did not like, do remember there was no greater friend of the First Amendment in the Supreme Court, and that there would have been no Heller without his 5th vote. You may not have seen also, but as Tom mentioned, the president did nominate Judge Brett Kavanaugh. The Washington Post sort of has now gone into full terror sort of alert, and it sort of now is telling us that, you know, we're in Italy in 1922, and that the onset of fascism is upon us. Would that it were the case, but no. Alas, no. You know, we're told that we're going to have a solid conservative majority on the Supreme Court. I have a friend whose anonymity I will protect, who sort of said to me, this is not me, by the way, I want to make this perfectly clear, that for all these people who are obsessing about how Roe, and Casey are going to be overruled, they don't understand that the women in the court, you know, Ginsburg, Kagan, Sotomayor, and Roberts will never stand for that. And so all of this obsessiveness just will never happen. So people should stop, you know, should read, you know, the Obamacare cases. And if you can figure out that state means federal, you know, the country will never sort of get to that. Please calm down. Anyway, so we should thank, you know, the president for doing, you know, the right thing on judges, as we have. We should also thank the Federalist Society. I think the Federalist Society has been perhaps only second to the president in being instrumental to the change in the legal community, the legal thinking, and the development of a legal culture that actually values what legal texts actually say and mean, and has been invaluable to the legal culture in having a cadre of people who actually care in the implementation of democratic values and having law be law as opposed to something else. And, you know, the society has been incredibly responsible and valuable in having the staffing of these courts be ongoing as it currently is, and the society too deserves a debt of gratitude. But I think we should also but there's a third group of people we should thank for this shift in the courts. It is, you know, the petulant liberals in the Senate. Because, you know, like a child in a science experiment who just could not wait to have 2 marshmallows later and wanted to have the marshmallow now, they had to blow up the filibuster over a cold trucker to please people, even though it was a mathematical certainty that Justice Gorsuch was going to get confirmed. And now they're naked to their enemies and trying to come up with all sorts of excuses as to why drinking beer and going to baseball are capital offenses. And so, you know, joke's on them. And so I think, you know, we owe them also a debt of gratitude for greed and stupidity. And so there you go. Now, speaking of which, this is probably a good transition. We have a tradition at this lecture, which I guess I should cover quickly. We usually give a prize for the individual in our culture who exemplifies egregious hypocrisy, crass dealing, and dishonorable behavior, and this being Washington and the country being what it is, you know, the list could be long. So, you know, you could go through a whole list of people. You know, there's always, you know, people. I mean, we can't have Hillary and Anthony Weiner every year. I mean, at some point, you know, we gotta have them term limited. But, you know, it is, you know, I consider Senator Menendez, because, you know, the whole thing about, you know, flying to the Dominican Republic and trying to figure out how to use a Me Too in Spanish. But, you know, the guy somehow managed to get acquitted. So, you know, okay, let's put him to the side and save him for a future year. He'll probably get into trouble again. And so there's, you know, the other possibility is the Harvey Weinstein of the Senate, Al Franken, the putative comedian. Someone actually thought worthwhile to go to Al Franken for a quotation when the FBI guy, Mccoy, was fired, and, you know, Franken thought this was hypocrisy at its worst, which I have to say, actually, he was a good source for, because he did practice hypocrisy in the Senate for all of 9 years. And even now, he's probably someplace with Anthony Weiner, sort of swapping photos and planning, the respective returns. And so he's probably a good source for that. But probably not as good for the ultimate prize as, say, Ron Wyden and Jeff Merkley, who did all they could to try to avoid, the appointment of Ryan Bounds. First, it was that they had not recommended them through their committee. Then it was, when the committee actually did recommend them, that they had not been apprised of something that the guy wrote in college. Really? And then it was, oh, gee, you're overlooking, the blue slip sort of tradition. And so, people just sort of admit, if you're a liar, and just let it go at that. But again, we can do better than that. So I think for the prize today, we have to turn to the truly despicable antics of Senator Dianne Feinstein. Now, Dianne Feinstein used to escape, notice and recognition because she used to be paired with Senator Boxer. And so that was a target-rich environment, because I don't want to go as far as President Trump has gone and described the intellectual gifts of certain members of Congress, but let us just say that Senator Boxer was never in danger of being invited to Mensa. In any event, Senator Feinstein sort of shined by comparison for many years, and from time to time, before she lost completely her mind, she seemed sort of sensible on some national defense issues. But as the rest of her party sort of moved extremely to the left, and she could just not let go of her ambitions to cling to public office, she moved with them to areas of complete irrationality. So during the confirmation hearing of now Seventh Circuit Judge Amy Barrett, she grilled Amy Barrett over articles she had written in which the then professor, now judge, had advocated that Catholics who had certain feelings about certain issues should, recuse from certain cases. Senator Feinstein was very troubled by this and sort of loudly accused now Judge Barrett by telling her that the dogma lives loudly within you. This was sort of a torture attempt to mix up Star Wars with bigotry, and not something that is sort of all that attractive in a public servant, even if she is 85, and at that age she should know better. And so she was completely unchastened by this. She went into that paragon of press impartiality, CNN, to try to explain that these writings were truly questionable, and she still could not explain what the writings were, which probably indicated that she had no idea what the writings were, and that this was all fed to her by a staffer. But in any event, Senator Feinstein is 85. And incredibly, she is running for re-election because in the very small state of California, there has to be no one who is capable of doing this job just as well as she can. And since, it is sadly likely that the voters in the state of California will return her to us, I think we have to give her, the award, and also sort of perhaps, remind her that there are parts of the Constitution that she should keep in mind in the future. Article 6 does say that no, religious tests should be imposed for office. For the left, who constantly tells us that the right is trying to take away our rights, one of these days they should dust up, the documents and actually read them. There are actually some that are in the Constitution. Anyway, turn to the term. The court had a total of 76 cases, 65 signed opinions, and 11 summary reversals. 26% of the cases, were decided 5-4. That was 19 cases. That was higher than the previous term, but in keeping with the historical norm. The previous term had been somewhat of an anomaly because we've had an 8-member court and the court had been treading water. The rate of reversal was 74%. If you get a case into the Supreme Court, the chances are that the court is going to reverse. The performance of the circuits is sort of hard to gauge because most circuits have very few cases to actually be fair to gauge. The one court that had a lot of cases, you guessed it, was the Ninth Circuit, had 14 cases. 12 were overturned, and so they did as they usually do, poorly. And so, every year it's either the Sixth Circuit or the Ninth Circuit. If you are a litigant with a case in those cases, you're completely hosed because the chances that you're going to get random justice are high. The justices more likely to agree with each other, you'll be shocked to learn, are Justices Ginsburg and Sotomayor. And the justices least likely to agree with each other, you'll be shocked to learn, are Justices Alito and Sotomayor. All is well in the universe. Long live Sam. We're going to start, now I usually try to torment you by starting with boring patent cases and describing arcane technology, but I think you've endured enough, and plus you had to listen to Tom. So I'm going to start with something mildly more interesting, some of the criminal cases. The first one is a Ninth Circuit special, Sanchez-Gomez. There was a challenge to a rule in which criminal defendants were, required to wear shackles. By the time, the case got to the Ninth Circuit, many of these people had either been convicted or pled guilty. You would have thought that made the case go away because they were no longer criminal defendants, they were convicts, their status had changed. The Ninth Circuit, as only the Ninth Circuit could do, said that, no, we're going to decide these important issues because we're going to think that this is a functional class action. And so they made up a class action, and they decided that these actually raise significant issues of due process. In a unanimous decision by Chief Justice Roberts, the court said no. Functional class actions don't exist. If you want a class action, there's this Rule 23. You file it. You have to comply with these requirements. Numerosity, that sort of stuff. B1, B2, B3. Read the rule. Come back to us. Keeping with the Ninth Circuit, we turn to Kernan versus Cuero. So a state court defendant entered into a plea agreement with the state, obviously. He was expecting to get 14 years. Before he was sentenced, the prosecutor he discovered that the defendant had another prior. State law actually required for the complaint to be amended to add the additional prior. Under state law, he then became eligible for a mandatory minimum sentence of 25 years. Okay, so they go back to the state court judge. This is all put on the record, and the judge says, well, you can have the plea back, so the plea is withdrawn, and the new charge is filed. The defendant says, okay, I'm going to plead guilty again, and he gets sentenced to 25 years. He then files for habeas corpus, and the case ends up in the Ninth Circuit, which says that in order to preserve the integrity of the criminal process, he must be sentenced to the original sentence, the one that, under the original pre-agreement before the extra priors were discovered. And over the dissent of seventh, Ninth Circuit judges, over the en banc dissent of 7 Ninth Circuit judges, en banc is denied. There are apparently 7 Ninth Circuit judges who are compos mentis. The Supreme Court summarily reverses in an 8-pager saying, no, there is no due process case that actually requires specific performance for the violation of a plea agreement, even if we assume there was a violation, plus the guy pleaded guilty again. And so get out of here. So getting back again, we have Kiselev versus Hughes. We're still in the Ninth Circuit, where the Ninth Circuit was faced with a lawsuit in which a woman had been shot by the cops. Now what happened was the cops were called, and they showed up, and there was a woman waving a knife. There was another woman near her, and despite the entreaties of the cops, the woman would not drop the knife. In a window of only 60 seconds, they took her down. She was injured, she lived, but predictably, there was a lawsuit. The other woman who was near her turned out to be the roommate, and they were having a fight over a $20 debt because the other woman had threatened to kill the other woman's dog. This is California. And so the two women, they make common cause to sue the cops. Again, this is California. And because this is California, you end up getting mucho bucks from the cops, and the Ninth Circuit says that the cops are not entitled to qualified immunity. The Supreme Court, again, 7 complimentous judges in the Ninth Circuit dissent from the denial of rehearing en banc, and again, the Supreme Court summarily reverses. They say, we have repeatedly told the Ninth Circuit, in particular, not to use general statements of law to deny qualified immunity to the police. The Supreme Court also went out of its way to quote with approval part of Judge Ikuda's dissent below, in which she had noted that the majority's analysis, quote, did not pass the straight face test. Okay, now we can't all be sort of centered on the West Coast, because I do remind you that President Obama did appoint judges to the DC Circuit. And so let's now turn to District of Columbia versus Westby. At around 1 a.m., District of Columbia cops show up because the neighbors called there is a loud party in which the neighbors described as a long-abandoned house. The cops show up, and the party is going. The house does indeed seem abandoned. There are lights and utilities. They go in, and there appears to be somewhat of an orgy and lap dances on the first floor. There are like dollar bills and everything. Some of the party goers sort of scattered. There is a second floor sort of action in which there is a woman in a bed on a mattress. There are several guys. There are multiple condoms, some used, some unused. And, the cops are trying to get to the bottom of this, and, they're told that this is a bachelor party. There is no bachelor. Nobody can find the bachelor. They're also told that this party has been organized by Peaches, whose name also apparently is Tasty. It could be Peaches or Tasty, and she is said to be the patroness of the house who is renting the house from the owner. Peaches also is not on the premises, but ultimately somebody gets her on the phone, and after back and forth, she sort of owns up to the fact that she actually is not renting the house, that nobody is actually authorized to be on the house. So after all of this, the cops round up 21 people in this bacchanal and take them in for disorderly conduct. Ultimately, these people get lucky and no charges are pressed, but this being the United States of America, naturally they sue, and the district court and the DC Circuit 2-1 uphold a $1 million award against the cops, denying them qualified immunity. In an opinion by Judge Cornelia Pillard, one of Judge Obama's appointees to the court, and over a dissent by Judge Brown. This is the panel. And, basically, the theory of the D.C. Circuit is that these people had no idea that Peaches was not renting the house. And how are they to know that this was not on the up and up? Because, everybody has orgies in an empty, dirty house. Anyway, there's an en banc call, and there are multiple dissents, including one by Judge Kavanaugh, who's basically writing a dissent going, you got to be kidding. At least there's qualified immunity here. And there is a counter argument filed by Judge Pillard saying, oh, it's a fact-bound case. So you can think of this as Judge Kavanaugh is writing the cert petition, and Judge Pillard is writing the brief in opposition saying, nothing to see here. But the brief in opposition fails, and the Supreme Court takes the case and unanimously reverses in an opinion by Justice Thomas, who basically says, this is not in the ordinary realm of experience, something that people do with their houses. They don't usually invite people to have sex and orgies in their houses, keep them dirty, and have this sort of behavior, and the contradictory conduct actually gave rise to probable cause. That got 7 votes. That got 7 votes and 9 votes for qualified immunity. And so Judge Kavanaugh was doing pretty well in the court. So good for him. There was another case called Class versus the United States, also coming from these parts where the D.C. Circuit also got overturned. Now, Mr. Class pleaded guilty. He drove up to the Capitol grounds, and he had guns in his Jeep. What do you know? There's a statute that says that's a no-no. And so he pleaded guilty to a federal gun statute. And normally, you'll be shocked to learn, when you plead guilty, that's it. The fat lady has sung. And you cannot then go up and take an appeal from your criminal conviction because, hello, you pleaded guilty. But this fellow then tries to take an appeal to the D.C. Circuit, and the D.C. Circuit says, go pound, you pleaded guilty. His claim is that, the statute violates the Second Amendment. Now, maybe this group is getting more sympathetic to the claim. In any event, the Supreme Court then overturns, the ruling of the D.C. Circuit, basically saying that even though you have pleaded guilty, under 2 cases from the 1970s, you can still continue to take an appeal when your argument on appeal goes to the very power of the state to prosecute you. And here, the theory is that, the unconstitutionality underlying statute means that, the conduct was completely unauthorized. Now, Justice Alito, joined by Justices Kennedy and Thomas, dissented from this, sort of calling the earlier 2 cases sort of wacky and shibboleths, and he's not entirely wrong, because this is going to be a principle that's very difficult to cabin. It's very difficult to separate things that go to the institution of the prosecution from things that go to the power of the government to actually prosecute you. And this may come back to haunt, the court in other cases as people try to get out of guilty pleas. We'll see. Now we got to sort of a more fun case, Mccoy versus Louisiana. These things only happen in the South. Mccoy was accused of shooting 3 members of his family, his mother-in-law, father, and son. He claimed that he had nothing to do with it. He was out of state. And this was sort of like the O.J. Simpson, defense, that the true culprits were the members of the police who were all corrupt and were all in it with the judiciary. Now, the problem for him was that, the cops and the judiciary sort of had him dead to rights because, the poor woman who was being shot actually called 911 and was heard calling his name. He was sort of chased. They found, his prints, physical evidence, and he had the gun on him that matched, the murdered gun when he was ultimately caught. And so this poor guy, Larry English, is hired by McCoy's parents to represent him, and he concludes that the only way to escape, the death penalty is to admit that the guy did the killings, but to sort of plead that he sort of bunkers and to have a mens rea defense. Now, McCoy is adamant that he doesn't want to do that, and that he wants to put in his insane, the cops are after me and the judges are in it too in several states. And, the question is whether the Sixth Amendment entitles him to veto the choice of defense that the lawyer did. Now, the Louisiana court says, no, the lawyer gets to do this, among many reasons, because you're putting the lawyer in a position where he might have to suborn perjury. And the Supreme Court, in a 6-3 decision by Justice Ginsburg, overturns that. Now, there had been a case in 2004 called Florida versus Nixon, in which the court had a similar issue where the defendant had been basically agnostic on the question whether the lawyer could sort of admit the actus reus of the offense, and the court had said that in that case the lawyer could do that. But in this case, the court said that there was a principle of autonomy here, that really the client gets to control basically whether he goes to hell under his own banner, and the lawyer cannot overrule that. And that there was no real question of ethics here, because if the guy really thought that everybody was after him, he could truthfully testify to his paranoid fantasies, and the judge could not be suborning, the lawyer could not be suborning perjury. Now, there are any number of things that are wrong with this, again, because they're difficult to cabin. Justice Alito basically took, the entire opinion apart. As he pointed out, the court had cabined this as raising the question whether the lawyer could admit guilt, when in fact, all the lawyer was doing was admitting the main element of the defense, but only one element. And there are many cases in which a lawyer may choose to admit, say, a prior conviction or some element just to get it out, because it's very harmful to have it be disputed. And then again, the court leaves all these questions open, and they will be coming back to the court as well. There was a case raising a double jeopardy issue, dealing with a prior conviction. Under Virginia law, you can get a severance if you have a prior conviction, and Mr. Currier did. In the first trial, he got an acquittal. Then he wanted to bar the second trial on the theory that he'd been acquitted. And there's a case, as you know, called Ashe versus Swenson, that has been interpreted by the Supreme Court as embodying something called a collateral estoppel sort of component of double jeopardy. And he wanted to take advantage of the fact that he had had an acquittal in the first case by basically saying, now you cannot prosecute me on the second one. The court got out of that by invoking what is basically a waiver principle, basically saying you agreed to 2 trials and you're going to have 2 trials. But what's interesting about it is that there were multiple concurring opinions by some of the conservative justices signaling that they may be ready to give the hip ho to Ashe versus Swenson, and indicating that they think it's inappropriate to import civil estoppel principles into double jeopardy law. So that's an area for those of you who practice criminal law that may bear watching. There was a statutory wiretapping case, Data versus the United States. If a magistrate gives you an order that allows you to listen in areas where he has no jurisdiction to listen, do you have to suppress everything, or just the areas where he was not authorized to tell you to listen? And the court quite sensibly said only the areas where he had no authority to send you. That's Data versus the United States. Collins versus Virginia sort of involves the so-called automobile exception, in which there was no automobile. This was the Virginia police trying to be a little bit too smart for their own good. They were casing the joint of this fellow who had stolen a motorcycle. They sort of knew the guy had stolen a motorcycle. They sort of followed him on Facebook, and they knew where he had, the motorcycle. So they were basically following him and looking at his house and waited for him to show up at home, and sort of walked up to his house, into his property, lifted the tarp, and they said, aha, and they took him into custody. There was no warrant involved. And, their basic theory as to how they could do this was, it's a motorcycle, it can move. The court, I know, says, nice try, but no, get a warrant next time. You can't walk into people's property just because there's a conveyance in it and claim that, because it could have been a conveyance on a public street, you can invoke the automobile exception. And Justice Alito, God bless him, he's a friend of law enforcement that, prosecutors have. He actually dissented. He thought, well, and I'm quoting, gee, I mean, you could have seen this from the public street, and the Fourth Amendment is neither an ass nor an idiot. Another Fourth Amendment case involved yet another arcane principle of Fourth Amendment law having to do with rental contracts. If you rent a car, Madame Bird went in and rented a car. Mr. Bird was waiting outside. He was not on the contract. Promptly, she turned over the car to Mr. Bird, who only a few hours later was on the Pennsylvania Turnpike with, I think, some tons of heroin on the trunk and speeding when the cops got a hold of him. Now, the district court and the Third Circuit took the view that his name was not on the rental contract and he had no standing to contest the search. The Supreme Court thought, no, that's not quite right. Your standing to contest, the search does not entirely depend on what a contract says. You have to sort of look at it more closely. This might be sort of a different case if he had stolen, the car, but in as much as he actually was authorized by the person who rented the car to have it, maybe he does have standing, so you should look at it again. This brings me to actually the most important criminal case of the term, Carpenter versus the United States. If you read the papers, this was the most important blow for privacy in the history of mankind. It sort of goes to show that the justices sort of vote sort of different when things might apply to them. So this actually sort of requires a little bit of background. Now, the Fourth Amendment, as you may recall, for those who have read it, protects the rights of people to be secure in their papers, houses, effects, etc. Right? Their papers. They're not the property of somebody else. And so you start sort of this story in the early 1970s where the authorities go to Mr. Miller's bank and they want the bank records of Mr. Miller. They're investigating him for some wrongdoing. And he ultimately is convicted. He makes a fuss about it, goes to the Supreme Court, and the Supreme Court says, there's no search here because these records are the bank records, they're not your property. You have nothing to do here, and in addition, you have no expectation of privacy in them because they are negotiable instruments, and you basically signed them and gave them to the public, basically. Okay, that's one. Then some years later, in a case called Smith versus Maryland, the question is whether the numbers you dial on your phone, ding, 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 and you transmit to the phone company, whether those can be given by the phone company to the government, and whether that's a search, right? And so, the court says no. Again, these are records of the phone company, and you voluntarily convey these numbers to them so that they could execute their business. So on the dual grounds that these are not your property, they're their records, and that you had no expectation of privacy because you willingly convey the information, this is not a search. Congress did not like, the outcome in Smith versus Maryland much, and passed something called the Tort Communications Act, which didn't change it that much, but it basically said that if you wanted to get a pen register, if you're a federal prosecutor, you have to go to a magistrate judge or a federal judge and show reasonable cause, not actual probable cause, but some reason as to why you need this, so that you're just not getting it just for kicks. This is not probable cause, just some valid investigative ground. And Congress thought that this was a good way of striking, the balance. And that was that. And so, the Fourth Amendment cases continue their march. In 1983, there is a case called Knotts, Knotts, in which the issue is whether if you follow somebody in their car all around, and you follow all their movements, whether that's a search, and the court said, don't be silly, you're on a public street where people can see you, that can't be a search because you're exposing yourself to the public. Says the government, in a case called Jones just a few years ago, that means we can put a GPS on your car and follow you that way and skip the actually having, to spend the shoe leather. The court says, nice try, but no. If you put a GPS thing and you don't have a warrant for that, you're invading the car, which is his property. Even if you could follow the guy, that's different from actually putting a GPS on the car, which is actually an invasion of the property. So you can't do that. And to close the circle, you have, the Riley case. Usually you have, when you arrest somebody, if they have a cigarette pack and you have drugs in the cigarette pack, you can search everything in the person. The case came to the Supreme Court just a few years ago. If you have a cell phone, can you then look at everything in the cell phone? Now, I had, the sense that California was going to lose that case when the Chief Justice basically took his phone out and said, you mean you can do this to me? And so California lost that case 9-0, and the court basically said cell phones are different because they are a repository of a vast trove of information, yada, yada, yada. Okay, so we get to Mr. Carpenter. Mr. Carpenter is a petty robber, and so he had nothing to do with his life but to recruit his petty friends and to go around robbing Radio Shack stores, which I didn't even know was still in business, and T-Mobile shops. And just to show that there is like poetic justice, he was ultimately being investigated for some 17 robberies. And one way that the cops, decided to tie him to some of these robberies was to go to telephone providers, including T-Mobile, and to get cell phone tower data. Now, cell phone tower data sort of is generated as a record of the public, of the phone company, when you are near a cell phone tower, and it basically pings you, and it cannot quite tell you exactly where you were, and depending on where you are, whether you're in an urban area or in a rural area, it could give you an approximate sort of location within several blocks or a couple of miles. But thanks to that, they were able to sort of place Mr. Carpenter close enough to several of these robberies that he went up the river. So the case goes to the Sixth Circuit, where Ray Ketledge, recently in contention for the vacant seat, wrote a beautiful opinion sort of explaining that, gee, under Smith versus Maryland and all of these cases, he loses. And then the case goes to the Supreme Court, where everybody's up in arms about, the loss of our privacy rights and yada, yada, yada. And the Supreme Court is being urged to overrule, the Smith versus Maryland case and the so-called third-party doctrine. Now, there's not a great mystery to the third-party doctrine. It's not like anybody made it up. I mean, there is this troublesome word there in the Fourth Amendment. I mean, it's not like, oh, gee whiz, like the third-party doctrine is something that the court made up. I mean, like, there is there. And so the court doesn't do that. But in an opinion by the Chief Justice, joined by the liberal justices, the court does overrule the Sixth Circuit. Interestingly, it's sort of a tour de force. The Chief Justice is a gifted advocate. You read the opinion, and then you put it aside, and you're not exactly quite sure what he said. It's sort of like a Kennedy opinion with sentence structure. And sort of like there are English sentences, and you nod along, and you go, and then you read it again and go, and therefore, But the net of this is he's not going to, quote, extend Smith versus Maryland. That's the first sort of appellate trick. The second appellate trick is that he says that this case lies at the intersection of Smith versus Maryland, which actually is sort of an actual principle of Fourth Amendment law, and a principle in Jones, the GPS case, and Riley, that a person has an expectation of privacy in his location. Now, there's no such principle in Jones and Riley. In fact, the holding of Knotts and Jones is to the contrary. And so then there's a footnote that says, of course, none of this calls into question any traditional investigative methods. He doesn't tell you what those are. And so there are 4 dissents, and just before I tell you what they are, I'm going to make one brief point about this. First, about the point that there are 4, and I'll try to do this quickly because time is pressing and we have other things to say. But one of the things you read in the press lately is about the looming conservative, majority. How we're back in Italy in 1922, and the one thing that's interesting to me is, the left-leaning justices, when they like an outcome, are willing to sign on an opinion by Justice Kennedy, say, the Obergefell case, that may be Hegel written in German and backwards, even if nobody says knows what the heck it says, but the bottom line is good, they'll sign on. There is no separate writing. There is no, attempt to evade the shame by actually explaining how you could actually arrive at this result in some cogent way. Just like, okay, here's the bottom line, I'm in. Now, the conservative justices, which are about to take over the country, cannot agree on lunch, okay? I mean, people ask you whether, federalism will be back or this other doctrine will be back. These guys cannot agree on the same theory of federalism, originalism, textualism, the notion that they're going to end up on the same opinion to move the court doctrinally when they don't agree on each other on how to do the job. Oh yes, the outcomes will move to the right, but you can read, the opinions in Carpenter or the Alien Tort Statute, to which we will get, and just see the intramural dispute about piddly things, while the other side basically writes and votes as a block. And this whole notion that we're going to have, the dawn of the right-wing court that is basically going to crush, the rest of the country is a pure fantasy. But we digress. So we lead with Justice Kennedy, who has a doctrinal sort of dissent, joined by everybody but Justice Gorsuch, so Alito, Thomas. And he basically says, hello, Smith versus Maryland. Then we have Justice Thomas, writing only for himself, who says Katz, the expectation of privacy case, is BS. I would get rid of it. Is made up. And he goes through the original briefing in the Katz case, the oral argument, how this was the idea of some law student and it's ludicrous and it doesn't work. Long Thomas opinion, going back to the beginning of time, only by Thomas. And then we have Justice Alito, who wrote a beautiful opinion, sort of making, the points that just make you feel for the poor man. The man has been sentenced to life in this insane asylum, and he must just be thinking, when do I get paroled? Because he writes this like, hello, in the first place, we're talking about a subpoena. Even when you serve a subpoena on the defendant himself, that's not a search because you don't go rummaging through his records. He's allowed to search his own stuff, and so that's not usually subject to the same Fourth Amendment standards. And so, point one, the common law and our law treats that differently. This is not, people coming to your premises and going through your stuff. It's a subpoena. Point two, this is a subpoena served on somebody else. Not your property, their records. What are you guys talking about? But the question that he raises is, okay, now that you have done this, what will this case do to the traditional investigative methods that you say you don't disturb but you don't discuss? And given how much of law enforcement and investigation does turn on subpoenas and searches, that's a very nice question, and I sort of expect that will be heavily litigated. Now, the interesting opinion is Justice Gorsuch. Justice Gorsuch is not buying any of the their part of the Fourth Amendment. He would overrule the third-party doctrine, and he would have gone to a common law analogy that would have said that at common law, giving your property to somebody else, even if it's a third party, may give rise to a bailment. And he sort of has a hypothetical that when you use your phone, you might be giving rise to a bailment of data, and that it's still your stuff, and that therefore you may be entitled to contest this. So he would overrule Smith versus Maryland, come up with a bailment theory. And the only reason he dissented was because nobody made this argument to him, shockingly. Go figure. And so since nobody made this argument to him, he voted with the dissenters. But in point of fact, he was more with Mr. Carpenter than actually the majority opinion. And so this is a very unstable area of law, a very interesting case. Everybody loved the outcome, but is going to give rise to a lot of litigation in the future, and I think is going to affect a very important area of practice. Moving quickly to some of the business cases of the term, China, or as the president would say, China, Agritech versus Resch, dealt with a very important question, whether the filing of a class action tolls the statute of limitations for later class actions. Now, as you know, if you file a class action and the class action is pending, while the class action is pending, the statute of limitations is tolled for individual actions until and unless the class action is turned down, right? So if I file a class action and the judge is contemplating whether to grant class status, whoever is named in the proposed class definition has until the class action is rejected to file his individual action. Now, this case raised the question whether instead of filing a later individual action to take advantage of the tolling, whether you can file piggyback class actions and in essence have follow-on class actions based on the American pipe tolling. You know, the Ninth Circuit has said yes. The Supreme Court 9-0 said no. You cannot piggyback class actions, only individual actions. Digital Trust versus Summers is one of those cases that gives you some hope in the court and sort of tells you that the court can occasionally read. Dealt with the Dodd-Frank Statute and the definition of a whistleblower. The Dodd-Frank defines whistleblower as somebody who gives relevant information to the commission, the Securities Exchange Commission. The Securities Exchange Commission, you'll be shocked to learn, in the Obama years had sort of expanded that in their own interpretation by regulation to say that if you also gave information to management, that was good enough. Mr. Summers, in fact, gave what he considered sort of incriminating information to his managers. He was later fired. He then tried to sue under the non-retaliation provisions of the Dodd-Frank statute, taking refuge on the SEC interpretation. The Supreme Court, in an opinion by Justice Ginsburg, unanimously said no. Under the statute, the definition is very clear. There is no room for any further embellishment by the commission, and the statute says you have to report information to the commission, period, full stop. So you're not a whistleblower. If you report the data to the management, you have to do it to the commission. Cian versus Beaver County employees, retirement, dealt with the weighty question whether you can get 1933 Act class actions out of state court under SLUSA. Now, the lay of the land here is sort of very quickly. The Securities Act of 1933, passed in 1933, deals with public offerings of securities. In 1934, Congress dealt with other parts of the Securities Act, the exchanges, later transactions. As the decades went by, we came to be acquainted with people like Mel Weiss and strike suits, and by 1995, Congress was concerned that this was a drag in the economy, so they passed something called the Private Securities Litigation Act. Now, this statute was intended to sort of fix, this problem with the strike suits, and mostly did so by introducing pleading standards, right? You can't make up stuff. Now, the securities bar, on the plaintiff side, being sort of inventive, reacted to this by moving to state class actions. And so rather than filing these in federal court, where they actually could no longer do these things upon information and belief and what have you, they just started filing in state court. And so Congress sort of rolled aside, sighed, and passed SLUSA. And SLUSA basically dealt with the problem by saying that if you filed a state class action, then you get to basically yank it out of state court and kill it. And the question here was, under the 1933 Act, since the beginning, you can file a federal case both in state court or in federal court, and that is a federal class action if you do file it. And the defendant in that case claimed that under SLUSA he was entitled to take that case out of the state court. The Supreme Court 9-0 in an opinion by Justice Kagan said no. SLUSA only deals with state law class actions. The 1933 Act is a federal statute, and Congress did not see fit to take that out of the state courts under SLUSA. That was 9-0 unanimous. We have an interesting case in Animal Science Products versus Hawaii Welcome Pharmaceuticals. This is a very arcane issue that is just fascinating and ended up with no real clear answer, and perhaps for the best. There are many cases in our courts that are governed by foreign law. And so, for example, if you have like an oil spill on the coast of Spain, sometimes you end up with a lawsuit in the Seventh Circuit. There was actually one Seventh Circuit case involving, Amoco. And there are cases of that nature involving price fixing and things like that. And so federal courts oftentimes are faced with amicus briefs or other expressions of interest by the government involved, trying to tell the federal court what their own law is. And the question is, what weight do federal courts give to the expression of interest of that government? Now, over the years, the federal courts have come up with a number of sort of approaches for that. Now, the D.C. Circuit had a case almost 10 years ago, maybe longer, which had basically taken the view that it was an act of state. Basically, you cannot second guess it. It is an act of state, and it is an expression of a sovereign of their own law. You have to take it at face value. The Seventh Circuit in the Amoco case said that you treat it like you would a federal agency because they have lawmaking power, and so you give them, the equivalent of Chevron deference. The federal government in an earlier case coming out of the 11th Circuit involving some criminal prosecution said that you should give them Skidmore deference, not quite Chevron deference, but Skidmore deference. And all of these issues made it to the Supreme Court in this Hawaii case, where the Second Circuit had basically taken a hard line, sort of akin to the D.C. Circuit, saying you have to give sort of complete deference to the Chinese government in saying that these price fixers were basically doing, the government, the government's bidding. And the Supreme Court sort of overturned that, but didn't quite tell us what level of deference really you have to give them. It's sort of, you have to consider multiple factors, the reliability, the this, the that, and I think it sort of boils down to you eyeball whether you're dealing with France or Venezuela, and you act accordingly. I mean, the court didn't quite put it that way, but it is a multi-factor test, sort of designed to sort of convey to the lower federal courts, you have to decide whether these people are like us. And that's that. We also had the Ohio versus American Express case. It was an antitrust case. It was sort of dull, except that apparently, the Obama administration and multiple states sued the American Express company over this. Now, this is sort of a common issue with credit cards. The American Express cards, if you have one, claims to be more selective than Visa or MasterCard, and you have sort of a different business plan. Now, their theory is that they give a lot more to members and perks and blah, 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 and in order to make that work, they basically extort it out of the merchants. Merchants don't like that because they end up sort of paying more when the client uses, the American Express. And American Express deals with that by having contracts with merchants that say that the merchants cannot steer the customer to use another card when the customer is used to is ready to make the purchase. So Amex comes to the merchant and says, I'm going to give you an extremely well-heeled base of customers, but you have to bite on this bitter pill. You cannot turn them away once they're ready to use the card. So I will get them into your shop, but you have to let them pay with the American Express. Now the government and the states took the view that, this anti-steering thing was a violation of the antitrust laws because it was anti-competitive with respect to the merchants. The Second Circuit disagreed, and the government and the states took the issue to the Supreme Court, where they lost 5-4. And an opinion by Justice Thomas pointed out that it was an error of the prosecution, in effect, to view this solely from the affected side of the merchant, and you had to take, the market both as comprising, the merchant side and the cardholder side. And because the government's theory did not encompass, the benefits to the cardholder under a rule of reason analysis, this was an appropriate thing for Amex to do and not anti-competitive at all. We get thus to the Alien Tort Statute, and I better move quickly. The basic headline on this is whether you're allowed to sue foreign corporations under the Alien Tort Statute. The answer is no. We have a splinter of opinions. Justice Kennedy wrote, the lead opinion, but again, joined by, the right-of-center justices. Very little of his opinion actually commanded a majority because everybody felt incumbent upon him to write a separate opinion as to how they would get rid of SOSA, or they would get rid of the statute, or they would shoot each other or something. They could not agree on anything about how this sort of analysis should work. That was that. Then we have the ever popular issue of arbitration in the Supreme Court. The Supreme Court held some years ago, you would have thought that you could use arbitration and employment contract in the Circuit City case. Everybody thought that was settled until the Obama administration union lawyers and the NLRB concluded that the NLRA actually had something to say about this, and they concluded that the National Labor Relations Act has a provision, Section 157, that says that union members are entitled to engage in concerted activities for mutual aid and support. And the theory of the Obama union lawyers was that if you had an arbitration agreement that, as in Concepcion, said that you had to arbitrate as an individual and not as a class, that was a violation of the NLRA because you were deprived of your right to engage in concerted activities for mutual aid and support. There were a couple of circuits that bought this, and as a result of this, the case had ended up in the Supreme Court, where, just to show you that we actually don't have a unified executive, even in the Trump administration, the NLRB continued to argue in support of this rule, while the Solicitor General argued on the other side. Two sides of our own government. The Supreme Court, in an opinion by Justice Gorsuch, said no. This NLRA provision has nothing to do with class actions. We looked for class actions as a procedure under Rule 23. There was a very anguished dissent by Justice Ginsburg. If I had more time, I would read you from it, but that'd just be cruel. I prefer to sort of save, my reading for the next case, where we turn to a little bit of the First Amendment, Minnesota Alliance versus Mansky. This has to do with whether the state of Minnesota can ban you from wearing a political badge, political button, or other political insignia inside a polling place on Election Day. Now, to be fair to this very cold place I hope never to visit, the Supreme Court in Burson versus Freeman had already said that you can have buffer zones where you cannot allow campaigning. This was in 1992. And for all intents and purposes, a polling place is a non-public forum where it's basically government property, and you can even engage in content discrimination. So, the state has a huge hang up here. Now, the problem here is that the state had this sort of standard that was based on what was political. And they had all sorts of weird standards that they distributed to their election judges on election day as to what was political and wasn't. And when they, even though the challengers lost in the lower courts, this got them into a little bit of trouble in the Supreme Court of the United States. Now, just so that you understand, the challenge here was brought after the 2012 election, and it took a while to get to the Supreme Court, and it was by a whole bunch of Tea Party people who were trying to show up at the polling station with big buttons saying, "Please ID me," and other sort of similar statements, and they got this being, Minnesota got into trouble. And the issue that caused the court a lot of trouble was the whole notion of how do you go about figuring out what's in and what's out. And so just to give you a flavor of how the argument went for the poor hapless advocate for the state who was sort of skewered for lunch by Justice Alito, this is one of the questions. Justice Alito, all right, how about a shirt with a rainbow flag? Would that be permitted? The advocate, a shirt with a rainbow flag? No, well, yeah, it would be permitted, well, yeah, unless there was an issue that had to do with gay rights. Justice Alito, how about a shirt that says Parkland Strong, gun control? Well, that would be allowed. Even though gun control is likely on the ballot? Well, Justice Alito, I bet some candidate would have raised gun control. Your Honor, well, what's the answer to my question? To the Parkland? I think in Minnesota, that would be allowed in. Justice Alito, okay. How about an NRA shirt? An NRA shirt? Today? In Minnesota? No. It would not, Your Honor. Justice Alito, how about a shirt with the text of the Second Amendment? Your Honor, that would be viewed as political. Justice Alito, how about the First Amendment? Laughter. No, that would be permitted. Okay, State Law 7-2. And even though it had every advantage going in, basically the Chief Justice wrote an opinion that quoted that exchange and said this is too vague. Next, First Amendment case, we have National Institute of Family and Life Advocates versus Becerra. The state of California, always on the vanguard, was not happy with people who were trying to counsel women who were pregnant to keep, the baby. Some of these outfits were licensed, some were not, and they basically concocted a scheme. I will spare you the details, because the hour is late, but basically the state law required these outfits, most of which were, religious and were advocating against abortion and in favor of pro-life causes, to post pro-abortion messages on the theory that abortion was a choice in all languages in the relevant county, usually 13, including Tagalog and Spanish and Chinese and all of these things. And so if any of these religious outfits wanted to have a billboard that said "Choose Life," they also had in the same typeface and in the same size to have an abortion size in 13 languages next to it. The court, in a 5-4 opinion by Justice Thomas, concluded that this was compelled speech and did not meet, the requirements for compelled speech. This actually is a case that will generate further litigation because, as you may know, the doctrinal basis for compelled speech is a case called Zotterer. And in order for the state to allow these sorts of things, it usually has to demonstrate that something is purely factual and uncontroversial. There has been a dispute in the lower courts about whether this is only allowed in relation with the state's efforts to avoid fraud or misrepresentation. There's an en banc case from the D.C. Circuit not too long ago as to whether you can force, meat producers to have country of origin designations, where the D.C. Circuit said yes, query after this case whether that's still allowed, because Justice Thomas takes the view that Zotterer actually is limited to trying to avoid fraud. But in any event, he also takes the view that abortion as a subject is too controversial, and because Sauter says that the disclosure has to be purely factual and non-controversial, you cannot sort of impose mandatory disclosure on moral subjects like this, among other things. And so you have that. There was a four-person dissent. It was sort of odd. Justice Breyer wrote a dissent in which he kept repeating, I kid you not, what's good for the good is good for the gander. Must be a doctrine that is native to his home planet. I'm not really following. But the basic gist of it was that in the Casey case, in approving the grand compromise that got rid of Roe and gave us Casey, the court had approved an informed consent law that said that a woman had to be advised that who was seeking an abortion, that adoption was an alternative. And his basic take was, well, gee whiz, if a woman seeking an abortion may be advised and a doctor can be compelled to advise her that adoption is an alternative, why somebody who's coming in to talk about adoption cannot be compelled to be told that abortion is an alternative? To which Thomas says, hello, when somebody's one of these people is coming in to be cut up for surgery, that's an informed consent law. Another person is just putting up a billboard. I think we're not talking about the same thing. And that was about, the level of the discourse. Next case is Janus. You may remember, the Abood case. Back in 1977, the notion whether public employee unions, if you decide not to join them, can hit you up for money on the theory that they're working for you anyway. The court said, yes, they can because they're the exclusive bargaining representative. And even though you may not like it and they may express views contrary to yours, your First Amendment interests are subordinate to the fact that the state has an interest in ensuring labor peace and avoiding your free riding on the efforts of the labor union. Now, this Abood doctrine has been on life support for a while. In the Friedrichs case, which was argued shortly before Justice Scalia died, it seemed just on the verge of being overruled. Justice Scalia died just a few weeks after the oral argument, and it's fair to say that the country was very sad at his passing, but the labor unions and the Democratic Party were a little bit less sad because they thought they had escaped a bullet. But the case came back in any event, and in Janus, the Abood case was overruled, and the Democratic Party sapped one of its major sources of income. Justice Alito made short work of the Abood rationales, pointed out that there are many states that have labor unions in which labor peace is just fine, even though people are not compelled to support the unions, that free ridership is not a compelling state interest, and that there was no reliance interest involved. And this is somewhat ironic because Sam Alito, has been telling the unions for years that he was after them. We had, the political gerrymandering case, Jill versus Whitford, in which we sort of escaped a bullet. Justice Kennedy has been musing for years about whether there can be too many politics in gerrymandering, and finally people had come to him with cases that had concocted a reputatively scientific basis called the efficiency gap, in which how to measure how many politics are too much in the districting process. The court, thankfully, got rid of the case on standing grounds. It was sort of a compromise, and this sort of tells you that Justice Kennedy, in fact, did not tell his colleagues that he was leaving, because Justice Kagan wrote a very extended concurrence, sort of trying to set up, the case for the comeback, which I think it probably won't do her any good. We had sort of a similar outcome in the Masterpiece Cake case, where again, there was an expectation that, the court was going to do a lot of work, with respect to the religious objections and speech objections of the cake maker, who did not want to make, the cake for the same-sex couple. I didn't spend a lot of time talking about it because Justice Kennedy got rid of that case, and another compromise where he said that it appeared from the hearing at the commission, at the state level, that the commissioners had been biased against the cake cake maker on the basis of his, religion, and he punted. Justices Kagan and Ginsburg, again, tried to give their roadmap as to how to basically screw the cake maker on the way back, sort of hoping that this will come back. And again, it may not turn out so well on the way back. And so we'll see what happens. There was the Husted case on whether, Ohio can clean up his voting rolls. That turned out, the answer was yes, even though, there was an argument that it was doing it solely on the basis of not voting. The court disagreed with that. Abbott versus Perez, another voting case, is just too boring to discuss. And so just let me say one final word about, two other cases, before we run out of time because it's sort of late. There was, the Lucia case dealing with the ALJ judges, the Appointments Clause case. It turned out to be predictable because the court basically found that these judges were officers under another case that was sort of similar, dealing with tax court judges. And so now the judges have to be appointed by the whole commission, which is not all that sort of a burden. There will be more interesting questions down the road as to how you get rid of them, and the removal questions that go with there being officers are sort of interesting, and that's what basically caused Justice Breyer to have a conniption. He's worried about whether we can have a civil service. Without further ado, I think we probably should say something about this travel ban case, because people seem to sort of think it was important. So now the president, you probably haven't noticed this, but he has a tendency from time to time to say improvident things. And so during the campaign, he made a statement to the effect that Donald J. Trump, as if somebody was going to think he was somebody else, was calling for the immediate stop of all Muslims coming into this country until our leaders figure out what's going on. After he took office, he went through some executive orders which were sort of stopped by the Ninth Circuit, but ultimately came to a third sort of proclamation, which was, the product of interagency, review, and was based on a lot of investigation by the relevant agencies of what sort of vetting certain countries do, and what information they share to us about the nationals that are coming to us. And on the basis of that, a number of countries were placed on a list subject to individual exceptions as to their nationals not being able to come into this country. Most of the countries, but not all, were a majority Muslim. This was sort of dabbed by the resistance, the Muslim ban. Shockingly, they sued in the Ninth Circuit, which promptly gave him an injunction. Now, they had two basic theories. Their main theory was that this was not authorized, which to this day blows my mind because, the president, relied on a statute. Now, I will read you the statute. It is Section 542 of the Immigration Nationality Act. Whenever the president finds that the entry of any aliens or any class of aliens into the United States would be detrimental to the interest of the United States, he may, by proclamation and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. Full quote. So Neil Katyal ginned up some theories as to how, you could not be a class of aliens unless you had some illness or disease, or you had some other sort of common law sort of defect on you, as opposed to just being a class of aliens, defined by just being from a country, for example. Ultimately, the Ninth Circuit bought some of these theories, and they also had some theory that this was a violation of the Establishment Clause because the president really meant to exclude only members of the Muslim faith. The case got to the Supreme Court. There was not a single justice in the entire Supreme Court, not even Sonia Sotomayor, who bought the statutory argument, okay? Because again, it turns out that the justices can read. Not even a single justice bought the statutory argument, which the Ninth Circuit had bought. The 5 members of the court concluded that this was authorized, and there was no Establishment Clause violation because ostensibly and on the face of it, this was objectively a reasonable action by the president. Significantly, a majority of the court focused on these actions as they impacted the power of the presidency. They were not sort of looking at this as the product of the statements of the incumbent occupant of the White House, but as they affected the power of the executive. 2 justices, Justices Breyer and Kagan, would rather take the ball and not play. Justice Breyer wrote one of these, on the one hand, on the other hand, this seems all sort of reasonable, and I'm not really saying that any of this would be illegal, and he actually says, I think a lot of this seems reasonable and it's probably legal, he says, joined by Justice Kagan, but it depends on how the case-by-case exceptions are actually applied and whether they're all really window dressing for something more nefarious. And I don't have enough information of that. And so I would keep the injunction in place until I have the information, which is sort of counterintuitive. And therefore, I dissent on that ground. But he's not saying that this is illegal. He's saying, I just don't have enough information, so I will give him an injunction, which is weird. Only 2 justices actually find this illegal, Justices Sotomayor and Justice Ginsburg. And they find it unlawful solely on the basis of the statements of the president, and they find it a violation of the Establishment Clause. So yes, it was 5-4, but it was 5-4 in an odd way in which only 2 justices could actually articulate a theory of illegality. And it's one that, is sort of an interesting theory on its own terms, considering that, the vast part of the world has majority faiths that are different from the majority faith in this country. And so if you went about sort of excluding massive immigration from most parts of the country, you ended up with the conclusion that we're establishing, I don't know what religion in this country. But in any event, I think that has been a very quick overview. I could tell you much more in more detail, but you're probably already asleep, and I don't want to hear people snoring. And I ate up all the time. Okay. Thank you.